Good afternoon and welcome. Philosophers and the founders alike stress the incredibly important role of property rights in forming a Republican nation. And protection of property rights stands as one of the bastions of our Constitution, from the Due Process Clause to the Impairment of Contract Clause and the Taking Clause as well. And issues of property rights are not merely a historical artifact. And many of you recall the incredible sort of firestorm that was sparked by the Supreme Court's decision in the New London case a couple of terms ago that allowed the city to take private property through eminent domain. And yes, we know that you wrote the opinion in that one. But in addition, those debates currently swirl, even including the foreclosure crisis and how to get out of the foreclosure crisis, because eminent domain stands as one of the proposals that's recently been back and forth in state legislatures. As in the New London case, though, it's generally the executive and the legislative branches that interfere with the enjoyment of property rights. But what if it's the judiciary's action that disrupts the settled expectation or the continuity to enjoy property rights? That's the issue that percolated to the top in the recent Stop the Beach case, which you have a description of you in the handout. But to set the stage a little more carefully,
ask this court to expressly recognize that a state court decision, unpredictable in terms of relevant precedents, which redefines century-old property rights to no longer exist, violates the Fifth Amendment of the United States Constitution. The Florida Supreme Court suddenly and dramatically redefined littoral property rights, converting oceanfront property into ocean view property to avoid the finding of a taking. It did so in the context of a beach restoration project which could have been accomplished without taking any private property at all. Given this court's jurisprudence that a state's legislative and executive branches cannot violate the Fifth Amendment, we see no reason why the judicial branch should be treated any differently.
I want to thank the OIA project of our Institute in the Supreme Court of the United States, or ISCOTUS, for the clip we just watched. And I want to thank the Jack Miller Center as well as MediaSite for supporting this event as well. But of course, most importantly, we're delighted in being able to have Justice Paul Stevens, who recused himself from the Stop the Beach case, with us this afternoon to continue the dialogue. And something Justice Stevens just told me, that indeed it was Justice Scalia who shared with him his talk on Stop the Beach here at the law school a year ago, which has sparked his talk this afternoon. So this will be, for those of you who were here before, this will be a response to Justice Scalia on the Stop the Beach case. And there's nice sort of dialogue amongst the justices from time to time, so we'll be able to watch one ourselves. And of course, Justice Stevens needs no introduction, needs little introduction. He served 35 years, almost 35 years on the bench, third longest in our history. And he made his mark in Chicago, but before that, indeed, was just taping a documentary about his role in bringing down corruption before he went on to the bench. His work on terrorism is important. In the Hamdan case, his work in administrative law, in the Chevron case, is the most widely cited Supreme Court decision, I think, for a score of years. And now commentators are stepping back and say, how will they describe the legacy of Justice Stevens? We know he's not an originalist, but is he a pragmatist? Is he a communitarian? Is he a civil rights zealot? I'll leave that for the legal historians among you, because I think the legacy of Justice Stevens is more wrapped up in his integrity. Everybody says, in whatever he's done and whatever he's touched, integrity stands out really at the forefront. The only exception might be his lifelong passion for the Chicago Cubs, even in these fruitless days. Justice Stevens has generously agreed to respond to questions after the talk. There will be no cards circulated around, so if you want to jot down your questions and pass them to center, someone will pick them up, and then we'll select a couple for the question and answer period. And the questions can be on judicial takings or on how beautiful Florida beachfront property is, but it can be on any topic related to Supreme Court jurisprudence that you like. I now would like to welcome Professor Nancy Martyr, one of our nation's leading experts on the jury system, who clerked for Justice Stevens in the 1990 and 1991 terms, to make a more formal introduction of the justice. Nancy?
Sorry. Thank you, Hal. This event could not have taken place without the support and encouragement of our dean. I hope you enjoyed the video that was playing when you entered the auditorium. I want to thank Jerry Goldman and Matt Gruen of the Oye Project for preparing it, and Steve Heyman and Carolyn Shapiro for appearing in it. I also want to thank Tara Anderson, our Director of Alumni Relations, for handling the many arrangements that go into an event like this. She did a superb job. I'm also grateful for the assistance of Janice Harley, who is Justice Stevens' secretary, and who also did a superb job. And for Susan Mullen, Justice Stevens' daughter, who's in the audience with us today and who accompanied Justice Stevens. We're grateful for her presence. As Hillary Clinton once wrote, it takes a village, and in our case, it takes an entire law school community to arrange a special event like today's afternoon with Justice Stevens. As many of you know, and as Hal mentioned, I clerked for Justice Stevens for 2 years, from 1990 to 1992. And although that was 20 years ago now, which, as my students pointed out to me, is a really long time ago, these 2 years made such a vivid impression on me that it doesn't seem very long ago at all. I have the privilege of introducing Justice Stevens to you, but of course I do it through a law clerk's eyes. As you know, Justice Stevens served in the U.S. Supreme Court for 34 and a half years. Justice Stevens was a great justice, and I think people of every political persuasion will agree, and here are some of the reasons why. Justice Stevens was the only justice who was not a member of the cert pool and made his own independent judgment as to which cert petitions should be granted by the court. He was the only justice who wrote his own first drafts of opinions, rather than relying on his law clerks to do this. He explained that the writing process was the only way to really understand a case, and that if an opinion did not write well, then it might indicate a problem with one's position. He wrote his opinions quickly, clearly, and in his own voice. He also wrote them often. He believed in the importance of explaining his views to the parties. Justice Stevens decided cases in a way that was protective of individual rights, prevented government overreaching, and respected the work of the other branches of government and of the lower court judges. In oral argument, Justice Stevens was always courteous to counsel. He often prefaced his questions, and they were always the toughest questions of the day, with the polite inquiry, "May I ask you a question?" Although my list could go on, there are other reasons that made Justice Stevens a great justice to his law clerks, and these are reasons known only to his law clerks, but I will share them with you now. No matter how busy Justice Stevens was during the day, he always had time to answer our questions. Even when we interrupted him in the middle of his work, he was willing to put down whatever he was doing and take time to talk to us. Justice Stevens was always appreciative of our work, even when we took a very long time to produce it. He made us feel that our efforts strengthened the opinion. Perhaps most importantly, Justice Stevens cared about other aspects of our lives beyond work. He knew our spouses and what kind of work they did. He met our families, and he greeted our friends. Undoubtedly, for all of Justice Stevens' law clerks, the best part of the day was the early morning, when Justice Stevens would come into the clerk's office, sit down in his big leather chair with a cup of coffee, and discuss the news of the day, the sports of the day, and the cases. Today, instead of a leather chair, Justice Stevens will take the podium, and afterward, he'll sit in the Ralph Brill chair, and he'll discuss a case that's been on his mind for a while. So it is with great pleasure that I welcome Justice Stevens, who will talk to us today about the 9th vote in the Stop the Beach case. Justice Stevens, welcome.
Thank you. You know, it just occurs to me, I may need that water before I'm through. Thank you very much, Nancy. One thing that I have especially missed during my retirement is debating points of law with my former colleague, Justice Scalia. I think he may also miss those debates because last year, when he delivered an address at the Chicago-Kent Law School discussing the Supreme Court's recent decision in Stop the Beach Renourishment, Inc. against the Florida Department of Environmental Protection, he went out of his way to describe my opinion for the court in Kelo against the City of New London as unpopular and unfaithful to the text of the Fifth Amendment takings clause, and therefore, quote, not long for this world, unquote. A few months later, in the Al Britton Lecture at the University of Alabama Law School, I explained why our decision in Kelo was so unpopular and how it was the dissenters rather than the majority in Kelo who wanted to change a settled rule of law. Today, I do not propose to repeat what I said in Alabama. Instead, I shall discuss the topic of judicial takings, which was debated among only 8 members of the Supreme Court in Stop the Beach, because I had recused myself. Stop the Beach involved a challenge to the constitutionality of an important Florida state statute. Responding to extensive erosion of hundreds of miles of sand beaches on Florida's coast, in 1961, the state of Florida enacted its Beach and Shore Preservation Act. Since the 1970s, over 200 miles of beaches have benefited from restoration projects authorized by that statute. Before the act was amended in 1970, the border between privately owned beach property and the state-owned submerged lands under the Gulf of Mexico and the Atlantic Ocean was a constantly changing line established by common law rules. Under those rules, the border was the mean high water line, MHL, measured by the average reach of the high tide over the preceding 19 years. The strip of sand on the shore between the low tide line and the MHL, like the permanently submerged land, belonged to the state. Gradual additions to the land, caused by forces of nature, became the property of the beach owner, while gradual losses of beach moved the property line in the other direction. Sudden and dramatic changes caused, for example, by hurricanes and known as avulsions did not change the pre-existing boundary line between public and private property. The 1970 amendment to the Florida statute effectively treated a beach restoration project like an avulsion. Under the amended statute, the common law no longer operates to increase or decrease the privately owned property in or adjacent to the restored beach. Instead, an, quote, erosion control line, unquote, set by reference to the current MHL, now serves as the permanent border separating public and private property. The statute contains other provisions that protect property owners by guarding access to and view of the water, and establishing procedures for determining compensation for any necessary taking of property. But it unquestionably authorizes projects that eliminate some property owners' right to accretions of land. In 2003, a city and county on the coast of the Gulf of Mexico applied for permits to restore almost 7 miles of beach by dredging sand from deep water and depositing it along the shore. A nonprofit corporation representing owners of beachfront property called Stop the Beach Renourishment, Inc., objected to the project, contending that it would destroy the owner's right to future accretions as well as the right to retain contact between their property and the water. The state agency approved the project, but the Florida District Court of Appeal set aside that approval. That court certified to the Florida Supreme Court the question whether the statute was unconstitutional, apparently referring only to the Florida Constitution rather than the federal Constitution. Over the dissent of two of the state court justices, the Florida Supreme Court held that the statute was not unconstitutional on its face. The plaintiffs had not specifically challenged the application of the statute to their property, and the Florida Supreme Court's decision did not foreclose future challenges to applications of the law. In its opinion, the court explained that the appellate court had failed to recognize the similarity between the common law rule that preserves an existing property line following an avulsive event and the statutory setting of a property line that remains the same during and after a restoration project. The Stop the Beach Corporation filed a petition for rehearing in the Florida Supreme Court, arguing that the court's decision had so flagrantly misconstrued Florida law that the decision itself amounted to a judicial taking that violated the Fifth Amendment to the federal Constitution. The Florida Supreme Court denied the rehearing petition without opinion. Presumably, nothing in the petition persuaded that court that it had misinterpreted Florida law. It would necessarily follow, I suppose, that the court did not believe that any possible state law error was so egregious that it amounted to a violation of the United States Constitution. Indeed, with respect to the federal issue, which was first raised in the petition for rehearing, the Florida court might simply have decided that it was too late to raise questions that were not encompassed within the question certified by the Intermediate Appellate Court. Following the Florida Supreme Court's denial of the rehearing petition, Stop the Beach petitioned for certiorari in the United States Supreme Court. I participated in the conference at which the cert petition was considered. At that time, I did not see how the outcome of the case could possibly impact the value of the condominium that my wife Marianne owns in Fort Lauderdale, Florida, or my own enjoyment of one of the most beautiful beaches in the world. The thought of disqualifying myself did not occur to me then. After the court granted certiorari, however, news stories suggesting that we might have an interest in the outcome persuaded me to recuse myself, so I did not thereafter participate in the decision of the case. Had I done so, I would have tried to persuade my colleagues to dismiss the case as having been improvidently granted review, because there was no justification for using it as a vehicle for discussing the subject of judicial takings. Ultimately, my recusal did not affect the court's disposition of the case. Both Justice Kennedy and Justice Breyer explained in their respective opinions that there was no need to decide the judicial takings issue, since the court unanimously agreed that there was no merit to the claim that Florida's actions constituted any form of taking. Nevertheless, Justice Scalia wrote an opinion that spoke for a plurality of four justices in espousing a theory of, quote, judicial takings, unquote. The remainder of his opinion spoke for the entire court in affirming the Florida Supreme Court's conclusion that there had been no taking. In his talk at this law school last year, he was critical of his colleagues for their failure to join his advisory opinion about the subject of judicial takings. Had I participated in deciding the case, I also would have refused to join Justice Scalia's advisory opinion, and probably would have identified at least three reasons for not discussing the subject of judicial takings in that case. First, if there had been any taking in the case, it would not have been a judicial taking. Any taking that might have occurred was affected either when the Florida State Legislature passed the statute also authorizing the creation of new, permanent, unchanging property lines to replace the ever-changing common law lines, or when the agency actually set the property lines that would preclude petitioners from acquiring further land by accretion. The main significance of Justice Scalia's characterization, is that my phone? That an appellate court's approval of challenged executive or legislative action is a, quote, judicial taking, unquote, than rather solely a decision on the merits of an underlying takings challenge, was to provide a special procedural benefit to property owners who, like Stop the Beach, failed to claim a violation of the federal Constitution until after the state courts have rejected their state law claim. As Justice Scalia explained in a footnote to his opinion, ordinarily the court does not consider an issue first presented to a state court in a rehearing petition if the state court did not address it. Quote, but where the state court decision itself is claimed to constitute a violation of federal law, unquote, Justice Scalia wrote, quote, the state's court's refusal to address that claim put forward in a petition for rehearing will not bar our review, unquote. For that proposition, Justice Scalia cited Justice Brandeis' opinion for the court in Brinkerhoff-Ferris Trust and Savings against Hill. But that case did not create a broad exception from ordinary procedural rules. It merely held that the state could not refuse to provide a taxpayer with any hearing whatsoever on its constitutional claim. In Stop the Beach, however, the plaintiff corporation had ample opportunity to be heard. It could have raised a federal constitutional challenge to the alleged state taking under the Florida Beach Preservation Statute well before its rehearing petition in the Florida Supreme Court. Indeed, the corporation's lawyers could have raised it, but did not, in the state court proceedings, along with the corporation's state constitutional challenge. Perhaps the most glaring omission in Justice Scalia's opinion is his failure to explain why there is any need to create a special procedural exception for property owners whose lawyers fail to advance a federal claim in state proceedings. He cites only one case to illustrate the importance of policing, quote, judicial takings, unquote. Webb's Fabulous Pharmacies, Inc. against Beckwith, in which county officials applied a Florida statute that expressly deemed interest on certain funds deposited with the courts to be public money. Ironically, however, conventional appellate procedural rules enabled the Supreme Court in Webb's to decide the federal question. The plaintiff there had challenged the state statute on federal constitutional grounds before the Florida Supreme Court, which had found no unconstitutional taking. In Webb's, unlike in Stop the Beach, the federal question was preserved and clearly passed on by the state court. I'll try the water. Maybe I won't. There we are. The second point I would have stressed, had I participated in deciding to stop the beach, is that it is the due process clause of the 14th Amendment, rather than the takings clause of the 5th Amendment, that gives the federal courts the authority to decide whether state judicial decisions announcing new rules of law violate the federal Constitution. While the court's 1897 decision in Chicago B&Q Railroad against Chicago is often cited for the proposition that the Fifth Amendment's takings clause has been incorporated by the 14th Amendment and therefore applies to state action, in fact, the Chicago opinion did not even cite the Fifth Amendment. As Justice Scalia more accurately stated in his Stop the Beach plurality opinion, Chicago held, quote, that the due process clause of the 14th Amendment prohibits uncompensated takings, unquote. In reaching that conclusion, the Chicago court also answered in the affirmative the antecedent question whether the due process clause applies to matters of substance as well as procedure. While Justice Scalia correctly described Chicago's holding, his Stop the Beach opinion elsewhere overlooks the difference between the Fifth and 14th Amendments. For example, at the outset of its discussion of the court's takings jurisprudence, Justice Scalia's opinion cites a case decided in 1871, Yates against Milwaukee, for the proposition that the, quote, takings clause, nor shall private property be taken for public use without just compensation, unquote, U.S. Constitution Amendment 5, applies as fully to the taking of a landowner's riparian rights as it does to the taking of an estate in land, unquote. In fact, Yates, like Chicago, took the form of a substantive due process case that did not even cite the Fifth Amendment. The primary difference between the two amendments, of course, is that the Fifth limits the power of federal government, while the 14th Amendment limits the power of states. Even if we assume that the scope of the Fifth Amendment's limitation on the scope of a government's power to condemn private property is coextensive with the 14th, it is noteworthy that neither the text nor the history of the Fifth Amendment's taking clause places any limit on the scope of that power. The clause only imposes a requirement that just compensation be provided for a taking. Prior to the Constitution, uncompensated takings had occurred both in England and in some states. That history explains why the text of the Takings Clause prohibits uncompensated takings. But the text does not limit the circumstances in which the government may take property. Instead, under the common law, as well as under the Due Process Clause, it was assumed that any taking, just like any regulation of the use of private property, must be justified by a public purpose. The omission in the Takings Clause of any textual restriction on when the taking power may be exercised is consistent with the view that the prohibition against deprivations of property without due process, expressed in both the 15th and the 14th Amendments, is the true source of the prohibition against takings for a purely private purpose. In both his Chicago Kent talk last year, in which he referred to, quote, the absurd notion of substantive due process, unquote, and in Stop the Beach, Justice Scalia argued that the due process laws cannot do the work of the Takings Clause. For a jurist who stresses the importance of text in the analysis of most legal questions, that argument is surprising. The prohibition against deprivations of property, quote, without due process of law, unquote, in the text of the 14th Amendment is more naturally read to extend to state judicial decisions on property law than is the text of the Fifth Amendment, which, as I have explained, merely prohibits federal takings without just compensation. Moreover, in the only opinion I have found by a member of the Supreme Court that would have treated a state appellate court opinion as the equivalent of a, quote, judicial taking, unquote, Justice Stewart's sole writing in Hughes against Washington, reliance was placed solely upon the 14th Amendment, not the Fifth. Notably, Hughes, like Webb's Fabulous Pharmacy, decided the merits of a takings claim by following conventional rules of appellate procedure. If the court is to adopt a new judge-made doctrine expanding its authority to review the constitutionality of state appellate court opinions, it should be called, quote, judicial deprivations, unquote, rather than, quote, judicial takings, unquote. For such a doctrine should apply to deprivations of liberty as well as deprivations of property. Beach restoration projects affect public beaches as well as private beaches, and may affect liberty interests as well as property interests. Such projects theoretically could result in unconstitutional rules that deprive individual citizens of previously established rights to use public beaches and to walk along the shore of private beaches in the area between the high water mark and the low water mark. If the Florida Supreme Court were to adopt a rule limiting beach access to citizens who provide photo identification proving their local residency, or to take a more clearly unconstitutional deprivation of liberty, a rule limiting access to members of a preferred political party or a preferred race, the deprivation would be so egregious that appellate review of the judicial decision itself in the United States Supreme Court might well be justified even before the new judicial rule was enforced against a particular individual. I can find no principled basis for creating a new rule of appellate procedure that gives greater protection to property interests than to liberty interests when, as I have explained, both claims are at bottom due process challenges to action by a state. In arguing that substantive due process cannot do the work of the Takings Clause, Justice Scalia relied on two opinions expressing a crabbed view of that doctrine. The plurality opinion in Albright against Oliver and Justice Black's opinion for the court in Lincoln against Federal Labor Union against the Northwestern Iron and Metal Company. The former case involved the deprivation of an interest in liberty. The latter involved the validity of an economic regulation that was not claimed to be a taking. The question in Albright was whether the Due Process Clause of the 14th Amendment constrains the power of state government to accuse a citizen of an infamous crime without probable cause. Unlike the 5 other opinions in Albright, none of which commanded a majority, I thought that the clause applied and required the state to establish the probable guilt of the defendant before making a formal accusation. In 1884, in Hurtado against California, the court had held that the state could use a procedure other than a grand jury to meet that requirement. But that was far different from a holding that there was no need for any probable cause determination. My dissenting opinion explained at some length how the court had rejected Justice Black's view that the express guarantees in the Bill of Rights mark the outer limits of due process protection. Instead, I explained, the court had endorsed the reasoning in Justice Harlan's eloquent dissent in Poe against Ullman, which describes substantive due process as a guarantee of, quote, freedom from all substantial, arbitrary impositions and purposeless restraints, unquote. Justice Black's opinion in Lincoln Federal Labor Union is, unsurprisingly, consistent with his narrow view of the guarantees afforded by substantive due process. As my Albright opinion explained, however, that view was rejected by the court as time went on. While Justice Scalia cited Lincoln Federal Labor Union for the proposition that the, quote, liberties, unquote, protected by the substantive due process do not include economic liberties, it seems to me more accurate to say that Lincoln is one of many post-New Deal decisions that apply a deferential, rational basis standard of review to economic regulations adopted by democratically elected legislatures and executives. Moreover, in the 1977 case of Moore against City of East Cleveland, my opinion in concurring in the judgment expressed the view that the doctrine of substantive due process applied to invalidate a municipal zoning ordinance that placed an unjustified limitation on grandmother's use of her property. And substantive due process was the explicit basis for the 1897 decision in Chicago, which remains the principal authority for federal review of state takings decisions. It is true that the court is appropriately cautious whenever it is asked to apply the doctrine of substantive due process in new areas, as I noted in my opinion for a unanimous court in Collins against the City of Harker Heights. Still, it is quite wrong to say, as Justice Scalia did, that this doctrine, which has developed over the years through the common law process of adjudication and is appropriately respectful of judicial precedent, is, quote, so flabby, so susceptible to judicial ipsy-dixit, that it creates a huge reservoir of discretion, that is to say power, close paren, in the courts, unquote. On occasion, a majority of the Supreme Court has misused the doctrine, most notably in the Lochner case, and again recently in McDonald against Chicago, which held that a constitutional provision, the Second Amendment, that was adopted to protect state control over their own militias should give federal judges a veto power over state regulations relating to firearms. But generally speaking, in the area of takings by state official action, the court's reliance on substantive due process doctrine, often articulated as the, quote, incorporation of the Fifth Amendment's taking clause into the 14th Amendment, has produced an acceptable body of law. My third point can be briefly summarized. In his famous concurring opinion in Ashwander against Tennessee Valley Authority, Justice Brandeis cogently identified several rules that then limited the court's approach to the adjudication of constitutional questions. Two of those rules are relevant to our discussion today. First, quote, the court will not anticipate a question of constitutional law in advance of the necessity of deciding it, unquote. Second, the court will not formulate a rule of constitutional law that is broader than is required by the precise facts to which it is to be applied. The rule defining, quote, judicial takings that Justice Scalia formulated in his Stop the Beach opinion and urged the court to endorse would have violated both of those rules of judicial restraint that I have quoted. Moreover, the heavy reliance on pre-existing state property law in Justice Scalia's opinion appears to vary from this comment by Justice Brandeis about federal courts' duty to defer to state judicial decisions, including those that change pre-existing common law rules. Quote, the process of trial and error, of change of decision in order to conform with its changing ideas and conditions, is traditional with courts administering the common law. Since it is for the state courts to interpret and declare the law of the state, it is for them to correct their errors and declare what the law has been as well as what it is. State courts, like this court, may ordinarily overrule their own decisions without offending constitutional guarantees, even though parties may have acted to their prejudice on the faith of earlier decisions. In Stop the Beach, there was no need for the court to fashion a new federal rule of law for judicial takings or judicial depositions, or to referee the dispute between the majority and the dissenters on the Florida Supreme Court over questions of Florida law. Moreover, the court should not have reached the merits of the underlying takings challenge to the Florida statute without applying ordinary procedural rules, that is, without first determining whether the federal claim had been decided by the Florida Supreme Court, or at least presented to that court earlier than in the petition for rehearing. I am sure Justice Brandeis would not have joined Justice Scalia's plurality opinion in Stop the Beach. Nor do I believe that Justice Brandeis would have found the reasoning in Justice Scalia's comments about that case in this forum last year persuasive. Those comments surely would not have affected my vote had I not been recused. Thank you for your attention.
So we now go to our second part of the event.